You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument.
Welcome. Our guest today is Wisconsin trial lawyer Mike Karp. Mike, welcome to the podcast.
Hey, man. Thanks for having me. This is awesome.
Hey, thanks for being here. So I had a chance I knew you by name, reputation. I'd seen some of the verdicts that you'd obtained, and then I had a chance to meet you out in California a couple months ago. But tell us a little bit about your practice.
Yeah. So I practice out here in Milwaukee, Wisconsin, where right now it's freezing. We were talking about that earlier. I grew up here, been here my whole life, went to University of Iowa for undergrad, met my wife there, came back here for law school, started off in practice, didn't start in personal injury. I actually started kind of floating around in family law, estate planning, a little bit of personal injury. But I figured out right away that I did not like family law. I did not like estate planning. And I was actually very close to just deciding I didn't want to be a lawyer. My last resort, I was practicing with my dad at the time. It was a small practice. It was him and one other attorney. And my last resort was kind of personal injury because we had maybe 5-10 calls a month, people calling. Most of them weren't even cases. But at that point, it was either try this, figure out if this is something you can do. And if you don't like this, maybe try something else. So I started doing personal injury, started gaining some traction with that. That made sense to me. And really what made sense about it was just the people aspect. I wasn't resonating with me with family law or estate planning. There was just no real human connection. But there was something about coming into somebody's life that had gone through something terrible and doing something good for them. Fast forward to, I believe, 2021, and I come across Trial Lawyers University, Dan Ambrose. It's kind of a interesting time with COVID and everybody taking a break from trials and coming together, brainstorming. So I was fortunate enough to come in right then, and my mind just got opened up when I went out there. And I saw what was possible, because at that point I didn't really have any idea of what it was like, any kind of concept of what a trial lawyer was. You know, I knew there were trials. I had never done a trial. There weren't a lot of lawyers in Wisconsin active back in 2021 that were trying a lot of cases. But I met a lot of people like you that, number one, struck me as phenomenal human beings, people that I just jived with and thought, these are good examples of leaders, of people that I aspire to be like, and got into trial practice, tried my first case in 2022, less than a year after Trial Lawyers University. And ever since then, I've been in love with the game.
Yeah, and so, a lot of your story resonates with me because when I was going through law school, I kept on checking off or Xing out the boxes of things I didn't want to do. Mm-hmm. And when I graduated from law school, I still didn't really know what lawyers did. And when I heard about different areas of law, my first response would be, I don't think I want to do that. And I just kind of need to get like a pinky toe in the door. And I got that with a guy named Neil Laurie, who's a wonderful friend, was my first boss, great guy. And he did some personal injury, some workers' comp, some criminal defense. I learned very quickly I wasn't any good at criminal defense because I'd look at the video and I'd be like, you did it. Now they might not have done what they were charged with. I get it. That's not a knock on criminal defense. I wasn't good at it. Workers' comp, yeah, but on the personal injury side, it just made sense. I mean, you said it so well and in a way that again, just resonates so much with me of like, okay, I understand this. One person did something wrong, caused harm to another person. The person who's been harmed, their life has changed, and it's my job to do something about it. Like, got it. Like that makes sense. If you ask me to do anything construction related, don't know how. If you ask me to practice many different areas of law, not very natural, but this just struck a chord. So I love hearing that. And I love, for folks who are listening, no matter kind of where they are in their career, you try in your first case in 2022, and since then, have just been on fire, man. Really, really remarkable. And the main topic or theme that we're hitting on today is all about how focus groups have informed your practice and specifically your trial practice. So share with us, how did you get started with focus groups? And then I'll just kind of give you the floor and follow your lead in talking about focus groups and their impact on your trial practice.
Sure. So when I went out to Trial Lawyers University, I think one of the things that really struck me was looking at a case from the perspective of a juror that's deciding what the verdict is going to be, as opposed to looking at a case through the lens of a personal injury attorney. Or I think we all fall into the habit of looking at it through a defense lawyer's eyes. And I learned pretty quickly in studying great trial lawyers on Courtroom View Network, where you can watch a trial start to finish. I learned pretty quickly that if you want to win a case and get a big verdict, that you have to first identify how you lose the case. And you have to identify what is it that a juror is going to be thinking about as they hear about the facts, as they see the evidence, as they hear the arguments. What are the questions they're going to have? Is this an important case? What was the motive of the defendant? What was is there a motive for your plaintiff? Has this kind of thing happened before? Is it going to happen again? Is the verdict going to change anything? So I got very interested in figuring out how to answer those questions before I got to trial. And I came across focus groups, and I was, realized that all the best trial lawyers were doing them. And I thought, you know what, this is also going to be a really good way for me to practice my skills and practice talking to people and figuring out how their mind works and how they're viewing the evidence. So I read Hitting the Bullseye, if you're familiar with that book by Scopter, and name of the other author escapes me. I apologize. And that gave me a really good foundation for how to run focus groups on my own. So I started doing them in my office. I'd just put an ad out on Craigslist, and I'd get, anywhere between 8 and 15 people that would come, pay them $10-20 an hour. And I'd just start asking them open-ended questions. What is this case about? What's important to you? What do you think happened here? And I realized really quickly that the way that I was looking at the case and what I thought was important was not always what the focus group participants were keyed in on. And when I started realizing, as much as I think we all value our own gut and instinct. And I don't think you should ever abandon that. I think that can be very useful. But if you're humble enough and you've done enough focus groups, you realize that it's not always right. And you really want to figure that out early in the case, because it helps you with discovery, helps you with case framing, and it helps you identify what the trial is really going to be about. So I started doing that in 2022. Now I've probably ran, I'm going to guess, over 100 focus groups, maybe 150. And they're instrumental to my practice.
So, Mike, let me ask you this for folks who are listening and say, I get the need for focus groups. I want to be able to do them in-house. I'd like to be doing what Mike is doing. How did you go about kind of structuring your time and your practice to permit you to do 100 to 150 focus groups the last few years?
That's a good question. I had to fundamentally change the structure of my practice and my business. So I used to have a docket of about 150 cases, which was way too much for one person, in my opinion. Obviously, as I started trying cases and getting good result, the type of case that I was handling changed. You know, it went from the standard rear end motor vehicle accident to premises liability, negligence, security, medical malpractice. I started getting into different case types. But I had to make a decision about going all in on being a trial lawyer, not just a lawyer that, you know, handled claims and negotiated with adjusters, but somebody who is going to be a force in the courtroom. So I dwindled down my docket from about 150 cases to about 40 cases. And that was around like 2022 to 2024. Now I'm at like 20 cases. I have a partner that I merged my firm with, Robert Welsenbach, who's a more experienced trial lawyer that started off as my mentor, and now we're partners.
That's fantastic.
And we make it a priority. I mean, really, all I do is court hearings, depositions, focus groups, trials. And so a typical week, you know, for me is focus group or two and a bunch of depositions. And when you first start doing focus groups, it's not going to be perfect. You're going to make a lot of mistakes and you're going to learn from your mistakes. I think the great trial lawyers and people who are successful in any industry are those that can adapt and learn from their mistakes. So you just start doing them, you get more comfortable in what you're doing. And there's a lot of really good resources and materials out there to help you structure your focus groups. It certainly depends on what kind of focus group you're running. There's different types. The most common type that we run is sort of a neutral, moderated discussion. And that's, I think, the easiest to get started with, because all you got to do is sort of go in and ask questions.
Yeah. Tell us about the role, the complementary role that either your partner or any staff members play in terms of filling in the other aspects of the case, things from completing discovery to kind of managing any type of intake process, kind of the other processes that, again, the rest of the jigsaw puzzle, if you will, in terms of a day in, day out legal practice.
This is something I'm always trying to get better at and figure out. And I think all great trial firms and trial lawyers are trying to attract highly competent people that can specialize in one aspect or multiple aspects of the case, because you cannot do it all. When you're going against billion-dollar corporations and they're hiring big time law firms and putting 6 attorneys on the case, and you got 30 motions in limine and a bunch of briefing, you can't also be the one focused on case framing, because something's going to fall through the cracks and you're not going to be able to focus your time and attention where it matters. So for me, I'm kind of a big picture guy. I spend a lot of time on the framing, on the focus groups. Bob is a technician. Bob has done a lot of class action lawsuits. He can bang out a killer brief in 3 hours. And we do collaborate a lot still on the strategy behind that, because as you know, everything's connected. But when it comes to building a great team, I think it's about identifying what the important roles are, what needs to happen, who's going to be responsible for that, and making sure that someone at the end of the day is personally responsible for those things. So we kind of split up our work. I do more of the jury selection, opening statement, closing argument, case framing stuff. He does a lot of the discovery back and forth, motions, briefing, pleadings, that kind of thing. We have one associate that's our third chair, and the team is growing, but I'll be totally full disclosure. That's a hard problem. It's a hard problem to solve when you're going against firms that have way more resources, way more attorneys, way more eyes on the case than you do. So that's something I'm still trying to figure out.
Yeah, I think all of us are. I mean, my reason for asking some of those questions about responsibilities, about structure, are largely selfish, right? Because I'm always wanting, and I think a lot of the folks who listen to this podcast are always wanting to figure out not only the what, not only the why, but also the how. So thank you for sharing that part with us. In terms of the focus groups, I mean, you made a really good point, which was conducting focus groups early to help it influence the discovery plan and also factor into case framing. Are you running multiple focus groups throughout a case? Talk about that with us.
Yeah, so we've got to the point where we're turning away 9 out of 10 cases, referring it to other law firms, being very selective about what cases we bring in. And most of the time, there are some exceptions, we're running an early focus group before we decide to take the case on, and just getting an initial knee-jerk reaction from people on, is this an important case? How important is it on a scale of 1 to 10? How clear is the liability? Who's responsible? And I want to know that, yes, you have limited information. Of course, you get somebody who calls you, you get a message in from your intake team or your inbox, and you talk to the potential client, you get more information. You might not have a lot of photos or exhibits to show, but I want to know right off the bat, is this something that is going to be worth 3-4 years of my time? This is going to be time away from my family. This is going to be time away from my other cases that I have at the firm. And I'm the kind of person, I know you're the same way from talking to you. If I'm going to put my name on something and I'm going to take the responsibility of representing somebody, I'm given 100%. I do not hold back, nor could I. It's just not in my nature. So we'll start early on, and then we'll run 10 or 20 focus groups on average per case. That looks like neutral, moderated discussion. It looks like single issue focus groups where we might just play portions of an expert's deposition. It's pretty remarkable how you'll come away from a deposition thinking you killed it, thinking, I just proved every element of the case through their corporate representative. And you play it to a focus group and it just hits flat. They don't, they're not lawyers. They're not worried about summary judgment. Sure, maybe you defeated summary judgment, but perhaps your tone, the way you phrase the questions, your pace might not have been effective for the people who are actually going to decide, do you win and how much do you win by? So we do them early, we do them often, we continue to do them. And then right before trial, I think focus groups, or you could call them dress rehearsals, are really, really important to get comfortable with your framing and get comfortable with what you're saying, because you got to believe what you're saying. It does not matter how many times you practice what you're going to say, how perfect it is, how many times you polished what you're going to say in opening statement. You better be able to look a person in the eye, and they better be able to feel that you believe what you're saying and you believe it's important. Because if you don't believe it, they're not going to believe it.
And Mike, for this many focus groups on a case, are you still using Craigslist, or are you finding your focus group participants by other means?
Yeah, we use Craigslist and we use Facebook. Facebook is incredible. I would say on average, when we put an ad out, we get about 80 responses, applicants who apply. We have a filtering process, and then we select usually 20 people because you have no shows. So it's variant how many people show up. And a lot of people say, well, that's a lot of work, like scheduling that, organizing that. The average focus group we run lasts 4 hours. And I'm doing them. I'm not delegating that or outsourcing it. I'm doing them. There are times when I will remove myself. I've taken the advice of a lot of great trial lawyers like Sean Claggett, who's obviously well known for running focus groups, that there are some cases that you are too emotionally attached to do your job as a moderator. And there are times when my partner and my team is really good at telling me, Mike, not this one. You're way too deep on this one.
Yeah, and so for again, folks who are wanting to run their own focus groups, Mike, share with us just some best practices on presenting the defense case.
Sure. That's a great question, because in my eyes, you don't run focus groups to figure out how you're going to win. You run them to figure out how you're going to lose. And in order to do that, you need to step inside the defense lawyer's mind. And I think plaintiffs' lawyers in general are always better defense lawyers than defense lawyers are, if you can separate yourself from the emotional attachment. So I spend an absurd amount of time thinking about how to put on the best case for defense and water down my case so that I can easily identify where I'm going to lose and where jurors begin to have a spike in their curiosity or openness towards defense arguments. I think you always got to be worried about the standard notice, foreseeability, defensive attribution, jurors feeling like, well, I never would have done that. I would have got a second opinion, or I would have worn different shoes, or, you want to test those theories out, and you want to test them out in an environment where you're not subconsciously doing it in a way that is going to make you feel good coming out of the focus group. That's not the intent of doing a focus group, to come out of it and feel good about your case. It's to get good, reliable information that you can implement into your framing.
And let's talk about, you've mentioned framing. When it comes to framing your case, based in part on the focus group feedback, tell us about your process in terms of case framing.
So we all kind of throw out case framing as this sort of umbrella concept. And, people have different definitions and ideas about what it means. To me, framing really comes down to, you don't win a trial by arguing better than the other side. You win a trial by deciding what the argument is. That's what framing is. You decide and you control what the disputes are going to be at trial. That requires a lot of meditation on what is the law in the case, what law is favorable to you that you can leverage, what are their positions. We all know undermining, Keith Mitnick, and putting things into context. what are their best arguments, and how do you flip those in your favor? Or there's a really good book out there called Winning Jury Trials. I don't know if you've heard of it or read it, but it talks about sponsorship theory. And sponsorship theory really comes down to which side is introducing the evidence and making that call. Do I, in opening statement, address this defense, or do I let them bring this up instead? Those are all things that should be running through your mind, and you should be testing those things in focus groups. We can all make gut decisions about that. I prefer to test it, and I prefer to test it again and again and again to be confident in it. So once I get through focus groups and I start to build a good idea of what the case is going to be about, what the winning frames are, what the winning arguments are, I start to box in the issues where I know I have the higher ground. And when I frame it this way, the defense is going to be explaining way more than me in the trial. Because I think when I think about cases I've lost, and I meditate a lot on that, I lost some because I had to do more explaining. I had to do more defending than they did. So the purpose for me at the end of all these focus groups is to have a position where I know when I go in there, my explanation is so simple, and the way I've framed the arguments, it's in my control, and it's on them now. It's their burden to try to unwind that and explain it away.
Mike, for our audience, can you give an example?
Sure. So let's say you have a premises liability case, and a very common defense in premises liability cases, of course, is notice and foreseeability, but another one is we gave some type of warning. There was a caution sign. An employee said, "Be careful," something to that effect. And if you just look at it the way I think a lot of plaintiffs' lawyers will on first glance, you go, well, it's not a good case because they were warned. They should have known. They should have been keeping a proper lookout. The deeper you go, you start to say, well, if they're warning about an issue, that would mean they know about the issue. The defense knows about the issue. They have notice. And then you start to backtrack and say, well, how long did they have that notice? How many times did they have to encounter the same problem where they made a decision instead of changing a policy or a procedure? They decided, well, we're just going to keep putting up caution signs, or we're just going to keep warning. And you start to identify different paths. Well, instead of trying to explain why they didn't warn properly, or instead of trying to explain why, despite the warning, my client was still acting reasonably, now I'm making a decision about, well, I'm going to use this fact to prove that they had notice. And obviously that's a really simplified, watered down way. But the point of the exercise is to say, look, the facts are the facts, but how you choose to frame how those facts are going to be disputed and talked about, which we have the most incredible position that we get to go first in opening statement. Once you lay it out as either A or B, and that now all the evidence is going to come in through that box and that A-B binary, you're going to have a really tough time as a defense lawyer if you thought you were just going to come in there and say, well, we gave them notice.
And the beautiful part about your frame is the defense is going to step right into it and think that they've got the high ground there and spend basically the entire trial unintentionally reinforcing perhaps your best arguments on long-standing notice.
Right.
You know, I remember this came up as you were talking about that. It came up years ago. We had in essence, a products case, and it was this toy, this baby bath, but the baby bath toy looked just like a carrier, right? It just looked like something you carry around a baby in. Like, it didn't look like a car seat. But man, it had the handle, it had everything. Like, there's no doubt about that a parent would grab it and lift the child. No, I mean, that's what the handle was there for. And on the side of the box in real small lettering, it said, handle not made for lifting. Do not lift child in baby bather. Well, of course, this little kid's dad was a year old, I think. Maybe not even quite a year. They're bathing the child. Dad goes to lift the child out. Handle breaks. Child spills. Fractures his skull in 2 places. And, it was like, well, we warned them. It's like, right. You warned them about this incredibly dangerous product. How much would it have cost to make a safe handle? How much would it have cost to create a different design that you no longer need the warning? I mean, in the product setting, it's always like design out, guard out, worn out. And here they could have very easily designed out the problem. They could have very easily guarded out the problem with a stronger handle. But the question of why they didn't do that, was it less expensive or was it not to try to put this small warning, on the side of a box that no one's ever going to see? Was that less expensive than fixing your product and making it safe? And the answer was yes. I mean, case resolved for a significant amount of money, not because the child got hurt necessarily, but because they knew they had a problem. They knew they'd had a problem for a long time. The Consumer Product Safety Commission had told them they had a problem. And rather than fixing the problem, they tried to transfer the burden over to an unsuspecting father's shoulders and blame him and add to the guilt that he was already experiencing for a child's damaged brain. But I love, again, the way that you made it. Like, if they're issuing a warning, it's because they know there's something dangerous. How long have they known? How dangerous do they know it to be? What would it take to fix the problem? And then what do they get up and do? Ladies and gentlemen, the reason we issue these warnings, they're basically parroting the point you made in your opening. So I love that. Well, let me ask you this. Go ahead, please.
That's a beautiful example because now you've reframed it into a choice. We're not talking about a pure warning and it's on the consumer, it's on your client to have read the fine print. Now we're reframing it into, you need to explain the choice that you made, knowing it was dangerous, not to make a safe product. And now we get into the motive behind that decision. And when you lay out that frame in opening statement and they had their little yellow notepad that they were going to come up and talk about the warning, that's a pretty hard thing to do when you have no anticipation that the case is going to be framed that way. And you were ready to give your little vanilla boilerplate opening that you've given 100 times in cases just like that. And now you're just going to avoid the whole frame. You're not going to give any explanation. So that's a really good example of what we're trying to figure out in the focus groups.
Mike, let me ask you this. In terms of focus groups, I'm real interested on what you like to do with your first witness, because it's something that I've talked about with Nick and other folks, but what you like to do with your first witness and how focus groups have influenced your order of proof.
That's The short answer is it depends. I don't have a go-to method that I use in every single case. There's different ways to look at it. I think one reasonable approach is to say, I want to go through liability, causation, damages. That's sort of a general blueprint that I want to lead the jury through. I will often put up a corporate representative, somebody who is going to confirm and corroborate everything that I said in opening statement. And I typically like that to be somebody from their side. I think, again, weighing the strength of the evidence, I'd rather have it come out of their mouth than come out of my expert's mouth, my client's mouth. But I spend a lot of time thinking about, on a case-by-case basis, what is right for this case. And I try to test that in the focus groups to figure out, where is the jury, what questions do they have, or do they still have after my opening statement that I can answer and put a dispositive, definitive stamp on it after the first witness. That said, I think there's always exceptions depending on the case. And I think that's one thing I've learned. You know, every trial you come away and you learn things and you reevaluate things. One thing that I'm constantly realizing is that there isn't one blueprint. Every case really is its own story. Every case really has its own energy, its own feel. And you should work during discovery, during the workup of the case, to figure out what is right for this case and what is right for the kind of lawyer that you are, for the kind of style that you have in the courtroom. We all know there's lawyers that are really aggressive, and that works for them. In cases that other lawyers, if they were to try the same thing, it wouldn't work. There's also lawyers that are very stoic and very clinical, and that works for them. I think there's so many variables that you have to factor in to figure out what's right for you, what's right for this case. So I know that's not a great answer, but it just depends.
And it is a great answer. And I'd much rather that be the answer than it's, citing line and verse or chapter and verse. Like whenever we get into, where people want to kind of law by numbers, and kind of these chapter and verse, and you got to do this way, and this, dogmatic, know what the answer is before the question is asked. That orthodoxy just makes me nervous, in part because the world is always changing, and that may have worked yesterday. You've mentioned, Mike, I want to talk about courtroom style. Before we get there, though, you've mentioned meditating. Are we talking about actual meditation? And if so, some recommendations and tips for lawyers on meditating? Are you referring more to kind of in a general sense of sitting back, thinking, and kind of the deep focused meditation on your cases? Tell us about that.
All the above. So I'm not somebody that wakes up every single day and meditates for 10 minutes. I wish I was like that. My wife is like that. She is consistent.
And real quick, we got to give a shout out to your wife. Your wife is designing children's clothes, in particular dresses, and one of her lines or multiple of her lines just got picked up by Dillard's.
Yep, it's launching in March. So she's been working really hard on that. I appreciate you mentioning it. It's called the Michael Karp collection. It's under the Edge Hill brand, and it should be in stores, I think, March 9th. So really proud of her, really happy for her. And she's somebody that inspires me to be better as a human being all the time. And she's encouraged me to meditate. And I think the end goal of meditation, because I don't think meditation is the only way to manage stress, manage your energy, become more present. I think what I really try to do is I get closer to trial, because we all know the feeling as you approach jury selection and you approach an upcoming trial, there's motions in limine, you're in court, you're fighting over things. Is this going to come in? How do we get this piece of evidence in? Is this witness going to be available? The doctor hasn't responded. Are they going to be able to come Wednesday? There's all this stuff going on. And that goes back to having a great team too, so that you're not the one having to stress about all those things and make sure all those things are getting done. But something I think is really important is just being aware of where your mind is at, being aware of where your stress is at. And so I really try to prioritize sleep. I try to prioritize mental and physical health through working out, through taking time during the day. I go into the war room prep. I'm working very long hours every single day, but I try to get out, get on the treadmill and walk. It's really cold here, so we can't walk outside, but just do something to take my mind off of the case, spend time with family, and just remember that I'm a human being. And as much as I care about this trial, as much as I care about my client, if I want to go in there and look human beings in the eyes and believe in my case and have that energy resonate, then I need to make sure that when I walk in there, I'm not just a ball of stress or adrenaline. Because that's the other thing too, is depending on, I tend to want to be clinical and stoic until closing argument. And then I really take off the gloves and bring out the bat. That's kind of my style. But if I'm not aware of myself, I can start to do that in opening statement. And I've done that before where it's worked out and I've gotten a great verdict. But in hindsight, or in talking to jurors after the case, they'll say things like, wow, you were really ramped up in opening. And I think that can work against you. I think juries are very skeptical when they first step in the courtroom and you're talking an opening statement, what the lawyers say is in evidence. They want to know that they can trust you. They want to know who's credible. And I think if you can slow down and you can show them, I don't have anything, you don't have to worry. This is a simple case. I'm not afraid of their defenses. The evidence is overwhelming. I don't need to be up here for 2 hours. You're going to see all the evidence. It's going to be okay. If you can have that energy, it's much better for the case, and it's much better for as a human being. Because that's the other thing you think sometimes, like I got 4 trials upcoming, February, March, and 2 in April, back to back to back. And I want to do this for a really long time, but I don't want to do it if I come home to my children and I'm just filled with stress and adrenaline and it's destroying me as a person. So I'm trying to figure out how to do it in a sustainable way.
And I love the point that you make on adrenaline too, right? For all that we hear about like stress, anxiety, I love the point that you make about adrenaline. Like the people who are close to me will be like, man, that fool, like he's keyed up, like, and I feel it. And the problem is, I know for me, one of the things that I struggle with is I like the way that feels in the sense of not the stress and anxiety, but that adrenaline burst, that shot that comes with taking something on, with presenting, with kind of being in it. The challenge, like, I mean, to your point, it's hard to then like turn it back down, eat well, listen well, sleep well, and repeat and sustain that. So I love you kind of adding, I don't think I've heard anybody talk specifically about adrenaline. I'm so glad that you brought that up. Mike, I was thinking about just in terms of trial presentations and focus groups and kind of bringing all these things together. What type of, if you sought feedback from your focus group participants, like on your presentation style on kind of what they found in terms of, for lack of a better term, what they liked or didn't like regarding the way you presented?
Yeah,
Or communicated?
absolutely. I think that's critical. So before we get to dress rehearsals, because by the time you get to dress rehearsals, it's pretty darn stressful to be like on a Friday before the weekend the trial's going to start and ask like the participants, so, hey, how did that work for you? And they're like, that's not when I want to know. That's not when I want to hear that or see that. I want to know that at least a month in advance so that I can make changes, because I don't want to be spending all Saturday and Sunday thinking, oh my gosh, how am I going to put this together and make this work? And when that guy said that and he didn't understand this. And so before we get to dress rehearsal, first I'll start with mini opening, try to condense the opening down to under 10 minutes, see what resonates. See what points they're like, when you said this, I didn't really know what you were talking about. I kind of lost you here. So we record all of our focus groups in 4K. We transcribe all of the comments. Everybody's mic'd up. And I'll go back and I'll watch not only for my own body language, performance, tone, volume, but I'll look at the body language of the participants and I'll try to assess where are they locked in and where do they start to lose me. And I'll refine and tweak, and I'll keep doing that until I land on what I think this is the final cut. This is what I'm going to present at trial. And when I get to dress rehearsal, then it's just getting really, really comfortable with that and what I'm going to show the jury at trial. I also think it's important to remember, and I say all of this as somebody who's made these mistakes and constantly makes these mistakes. I'm not over this. This is why I do them so often, because I'm always making mistakes. Sometimes I think we think of opening statement as like a presentation. And there have been times where I've been really PowerPoint heavy. And it's almost like, I'll look back after a focus group and I'll be like, that kind of seemed like I was like pitching venture capital or something. Like it was just really disconnected. It was way too heavy on the PowerPoints. I was just kind of talking to myself for 30 minutes, even though it sounded really good and I think the framing was right. And so because I know that of myself, I will do these focus groups and do these practice reps to remember I'm not presenting, I'm talking to them. I'm having a conversation with these jurors. And a conversation means two-way. I need to be able to look at you and get some energy back to know what do you need? Are you the kind of person who needs a visual? Are you the kind of person who needs me to look at you? Some people, I talked to Dan Ambrose a lot about this. I did the boot camp. And I was telling him, I said, sometimes I'm up there. Some people don't want to be looked at right in the eyes. Or if you do, you just want a quick glance and go away. Other people, they kind of want you to engage with them. And so focus groups give you a lot of practice doing that. If you don't ever do that, you do that once every 2 years when you get in the courtroom, it's going to be awkward and it's going to be stressful. And it's not just going to be awkward for you, it's going to be awkward for your jury. So I try to do that as well.
Excellent. Man, I could, when we met, I was like, what a great guy. I've been looking forward to this episode for a while. Mike, what have we not talked about? What else do you think would be really, really important for folks to know, either as it relates to focus groups, as it pertains to trial presentation, as it relates to taking care of yourself? Take a few minutes and cure the world's ills and bless the lawyers across the country.
I'm curious to hear from you on this, because I think about this a lot. Everybody's got a personal identity. And I think when you go out to these conferences and you meet great trial lawyers, you spend time around trial lawyers a lot, Um, you are who you spend time around. And there are times when I look in the mirror and I tell myself, I'm a trial lawyer. That's who I am. That's what I want to be. I want to be great. But there's also times you go on vacation and you remember I'm just a human being. I'm a father. I'm a husband. How do you balance that? And how do you think about that? Because there are times when I definitely struggle with giving 1,000% of myself to this practice and forgetting that, I need to enjoy life, smell the roses, and just be a human being too.
Yeah. So it's something I think about every day. I think probably the same way you do. And I don't know that over the course of like a month or kind of a long period of time that balance is realistic. Years ago, I got introduced kind of this idea of like a counterbalance. And I think counterbalance is essential so that things don't become too out of balance. And what I mean by that is if you got a trial, it doesn't have to be a long trial. In fact, I love what Geoffrey teaches on distilling down to the essentials of what you have to prove to win. But no matter what, I know there is for me, a temptation to kind of go from one thing to then playing catch up, to then feeling like I'm caught up, to then grabbing the momentum and trying to push higher. But if I do that, my wife gets shorted. My child gets treated as a distraction or interruption from work. When I saw this recently, they were talking about, the real work is our family. The real work is our child. The email, the text message, the phone call, that's not work. Those are the distractions from our real work as a parent, as a husband, my dad's still alive, thank God. And I think kind of maintaining, I was talking about with our team this morning, maintaining that awareness that at some point, just like that, like we see in our cases, just like that, it's all gone. It's over. We will never again speak to this person. We will never again have the opportunity to, right? Like there will come a day where my child no longer knows me because I'm gone. There will come a day where I'm no longer able to pick up the phone and talk to my dad, right? So I think kind of having the awareness helps maintain some degree of perspective, because I'm not going to get that perspective. I love my clients. I'm not going to get that perspective from them, right? I care about the people with whom I work, but I'm not going to typically get that perspective there. And speaking with lawyers about a case that's not typically primary, you know the deal. The conversation we're having right now isn't the majority of the talks. Usually it's, hey, Mike, what do you think about this case? Hey, Mike, I got an issue. Hey, Mike, I want to run a case by you. Hey, Mike, what do you think about this doctor, right? Or what do you know about this expert? What do you have here? So I think for me, I say all that to say that if I'm dialed in on work, if we're getting ready for a case, if it's preparing for a deposition, if it's running a focus group, if it's meeting with a lawyer to review something, whatever it is, I think the more I can be there, like here it's nice because I've got do not disturb on, my phone's turned off. So I can be present with you. It's wonderful. It's like, man, this is great. Yeah. I think kind of taking that same, people talk about intentionality. I get that. Like I totally get that. For me, the word focus resonates more. If I can really focus in and kind of remove away, and as best as possible compartmentalized, where, typically between like 6 and about 7:30. Yeah, it's the time I'll get with my daughter in the evening. Mm-hmm. There's, I might get interrupted by a phone call. I might have to respond to something. I might have to, again, there are things that I might have to do, but I think limiting it there so that we get that really quality time and same thing as best as possible in the morning. I think that then permits me to, between 8:30 and 5:30 or whatever, right? Sometimes, the deal. Sometimes it's from 6 in the morning until 11 o'clock at night. But, on an average give or take day, if I can be really dialed in here, give or take from 8:30 to 5:30, then there's some degree of balance. And on those weeks where it's 6 or 7 in the morning until 10 or 11 at night, then instead of setting a catch up weekend of this week, being like, okay, I am going to spend a week to catch up, and the following week after that, I'm going to take 2 or 3 days off and plan something ahead. If I know we're going to be in trial this week, or I know this is coming up, then 2 weeks out from there, putting a long weekend on the books with my wife. Or if we're gearing up for a case and it settles the Thursday before trial, rather than, immediately start throwing everything back on my calendar, say, damn, that was nice. Can I take 2 or 3 days or a week off? I've got a buddy of mine. He had a couple cases settled back to back when he was supposed to be in back-to-back trials. He took his wife to Paris for a week. Well, that was brilliant. Yeah. Well, it was a brilliant idea. I say all that with the asterisks of, man, it's a daily challenge. Because when I'm at work, I want to keep working. Yep. Like, I have a tough time. For me, first, I mentioned compartmentalization, but truth is I have a tough time transitioning from like one activity to something else. So if I'm doing this, man, I could do this for another 2 or 3 hours. Like when we go to conferences, I love it because we're immersed.
Right.
I struggle to then, pop back up for air and move on to the next thing without there being kind of some a tide that follows me.
Yeah.
So I don't know, but I mean, here's what I'd say. The fact that we're talking about it and thinking about it and working on it, is a huge positive. And I believe too, like if I put, and I don't mean in a ritualistic sense, it doesn't have to be in a religious sense, but if I'm doing my absolute best, based on kind of like my God and my values and my principles and my family, if I'm doing my best every day and making a conscious decision to try to, serve in essence, kind of a power or cause greater than myself, I think I'll be okay so long as that does not lead to self-righteousness and a sense of indignation, which are two of my kind of red flag indicators that I've gotten off track.
100%. That's beautiful. It's hard to turn it off. That's why I said that, because I forgot who said it, but someone has this exercise where you imagine yourself, 89, 90 years old on your deathbed. You're withering away. You have a few hours left and you're reflecting on your life. Your loved ones are around you. You're saying your goodbyes. And you get the opportunity as yourself at this age to go talk to your 90-year-old dying self. What would your 90-year-old dying self say to you looking at you right now? And how would you feel about the way that you spend your time and where your focus is and where your energy is? And what would really stand out to you as being important in your life? Would you be thinking about that case that you shouldn't have won that you won? Would you be thinking about all your great verdicts, or would you be thinking about your family? Would you be thinking about, that moment that your daughter was giggling on the playground and you were all eating ice cream? What would come to mind, and what moments would you want more of? And that's what I really appreciated about Outer Realm when we were out there, and they were talking about ego death and just living a full life, whether that's in the courtroom or just your everyday. So it's nice to talk to you and other trial lawyers that get it, because this lifestyle is, I'll find myself at like a party or something talking to other people, and it's almost like a deposition. I'm just like, get to the point. That's not the question I asked, or, non-responsive answer. And I look at it and I'm like, man, I need to manage. I need some more balance in my life, because I don't want to be that person all the time.
I can tell you I'm terrible at parties.
Mm-hmm.
I'm so bad at small talk.
Yeah.
I'm just so bad at it, man.
Me too.
Because it falls for me. I hate to say this, but I'll say it. Like, I just, if I could be like, honest, which would fall under kind of being brutally honest, I just kind of want to tell people sometimes, like, I don't care.
Yeah.
Like, I'm glad you had a good time. I'm glad you made that on your investment. Like, right. I don't care. Like, right. any more than you care about me telling you, some shit that is just an ego stroke.
Right.
I will say, I think, to your point though, man, I was talking with, do you know Chris Finney in St. Louis?
Yes.
Man, close friend, amazing guy, just a wonderful, wonderful person. He's got 5 kids.
Oh, wow.
Full-time practice, trying cases left and right. He and I talk about these things a lot, and we were talking with a lawyer from North Carolina who'd reached out with some questions. And one thing I mentioned to the fellow from North Carolina, Chris and I are both big on, is just like having a community of people who understand and like care, right? Like, who get it just like that.
Yeah.
I think that's really important too, because if I felt all by myself doing this, it would just get so lonely. I mean, it's sometimes lonely anyways, but it would be lonelier. So I think, it's one of the things I really enjoyed about the Outer Realm. It was like, man, look, here go 120 or so people, who are kind of all about helping human beings and standing up for the civil justice system, who are all like very different people too. Like, it just wasn't, if you got together 120 lawyers in Milwaukee, it would have looked different than what we saw out there. If you got together 120 lawyers in South Carolina, it would look a lot different than what we saw out there. But I think finding a community of people, and it's one of the things I've enjoyed about this podcast, of like, and going to conferences, right? Like what Dan Ambrose has done with TLU is remarkable. I mean, just remarkable. And the number of people who convene, and even if they don't find exactly what they're looking for on that given day with that specific seminar, conference, whatever it is, I think they're getting closer. We had this conversation with Claggett, and Chris Finney and I talked about it another time, but like a lot of us who years ago went to reptile stuff, and it has utility, it has application. God bless, Don Keenan for a lot of things I learned from him when I was a brand new lawyer. I'll be forever grateful for that. But it's interesting to see a lot of people that I met in that world who are such kind of lifelong learners and have continued to go, be it to TLU, Trial by Human, Jerry Spence Method, Trial Lawyers College, whatever, right? Like they're just people who are committed to getting better. So I think finding that community of people, it might be people in your building, it might be down the block, on the street, in your city, in your state, or somewhere else in the world, is reinvigorating.
1,000%. Agreed.
So, Mike, share with people, no matter where they may be in the country. Now, are you handling cases outside of Wisconsin as well?
I'm just starting to. So I'm actually planning on taking the California bar in July. I've tried my first case out there last year in April, working on getting licensed in Illinois. But yeah, starting to branch out.
Awesome. For folks who want to reach out to you, be it about focus groups, trying a case, kicking around ideas, being part of this community, what's the best way for people to get in touch with you?
Yeah, I would love to talk. I'm so grateful for our friendship and connecting with you at Outer Realm and everybody that I've met in the community. That would be my takeaway is having community and being able to emerge from the dark depths of trial preparation and talk to people that know what life is like, that also have kids or more kids and still make it work. But you can reach out to me. My Instagram is Mike from Milwaukee. So that's easy. Otherwise, www.trialwi.com. You can reach out to me there, or my email is michael@trialwi.com.
It's awesome, man. I've enjoyed this. Hell, thanks for asking me a question on here. That was fun.
Oh, yeah, I'd love to ask you more, but we're going to have to catch up.
I look forward to it, man. I look forward to it. This is the next, hopefully in a long line of conversations, and I learn stuff every time we do one of these. I've really enjoyed this episode, and I'm sure that the audience has as well. Thank you very much for being with us, and for everyone who's listened today. Thank y'all so much. This has been Best Practices with Kenny Berger. Our guest today, Wisconsin and soon to be Illinois and California trial lawyer, Mike Karp. Thanks so much. Thanks for listening to Best Practices with Kenny Berger. This podcast is produced by my law office. We are a trial firm based in South Carolina focused on life-changing injury and wrongful death cases. Here's the deal. If you find these conversations useful, if you think they've benefited you or might help somebody else, please follow the show and share it with other trial lawyers who might appreciate it. Lastly, thank you so much for listening, and we look forward to seeing you next time. Take care.